dealt various spectrums of law, that is writs on the original side, drafting, convincing, arbitration, consumer protection law, plus writing of books. And then the most important facets in his resume I found was that he had been a member of the Law Commission in respect of changing of the law aspects under the Arbitration and Conciliation Act and commercial codes. Therefore, to call a person who was, I can say, a catalyst or a trigger point to suggest his issues and aspects in these two vital laws and the acts, his association and giving his knowledge to this relevant topic, though all topics are relevant, but as to how we proceed during these testing times would also be one of the aspects wherein Mr. Rajah would be sharing his knowledge. He has also co-authored a book on Consumer Protection Act, and he has been conferred various awards. So much so, he has also been awarded as a living legend by the Bar Association of India. That itself speaks the volume of the speaker. As we have always been speaking about, that our entire endeavor is to bring the speakers whose knowledge are all pearls of wisdom. And as we always talk, that we don't give the introduction because the speakers whom we bring have so much in their resume that we can even talk 15, 20, 30 minutes only upon them. But the entire pursuit is to have knowledge from a person who is himself a knowledgeable person. And without taking much time, I would request Mr. Rajah, who is seated on a working day, to share his knowledge on a very relevant topic on today's time. Over to you, sir.
Thank you, friends. I thank the organization for inviting me to talk on a topic which is going to be very important to the members of the bar. And it is only our collective effort that can transform what I call an infant legislation into some sort of a model law, which will determine the manner in which civil suits are going to be decided in future. Because it's the success of the working of the Commercial Codes Act which is going to determine whether many of these procedures which are now stipulated under this act are going to be followed for all civil suits to make the job of adjudication and litigation in civil courts time-bound, meaningful, and useful to the litigant. I must start with telling you that there really are two types of legislations. Very broad classification of legislations will fit them into two categories. One is legislation relating to substantive law, and the other is legislations relating to procedural law. Some legislations are purely substantive law. Some legislations are purely procedural law. And if you look at the evolution of various legislations, that you will find that in the British time, there was a sort of a strict compartmentalizations of these legislations into these two boxes, as I would say. For example, if you take the Indian Penal Code, it is substantive law. If you take the Criminal Procedure Code, it is procedural law. If you take the Indian Contract Act, the Specific Relief Act, some of those legislations which were brought into effect by the British in the 19th century, these were purely substantive laws. And then you had something like the Code of Civil Procedure, which was a purely procedural law. But with evolution of the law, the needs of the time, the complexity of human affairs, and the need for creating more and more authorities under various legislations, many of the laws that roll out today are a combination of both substantive law and procedural law. For example, if you take the Companies Act, it has provisions relating to substantive law with regard to what are the rights of the shareholders, what must a prospectus say, what is a misrepresentation in a prospectus, how is a company to declare a dividend. All this forms part of the substantive law. with regard to Companies Act. And then there is a procedure with regard to what type of applications must be filed before the registrar, in what manner must it be filed, within how many days is it supposed to be disposed of. All these are procedural laws. But then you don't have two acts you don't have a Companies Act and a Companies Procedural Laws Act. Both are combined within the same legislation. But as far as the Commercial Codes Act is concerned, it is largely, and I might even say that it is solely a procedural law. It seeks to supplement CPC. It seeks to make some changes to CPC. And then the question arises, so what is wrong with CPC? Well, I think the answer is quite obvious. If you look at the ballooning delays in our legal system, and the fact that litigation today is driven by the litigants, it is not driven by the courts, right? And many times the courts say they feel helpless because innumerable adjournments are sought. Advocates say that when we are ready, the courts are not ready. So this becomes a bit of a seesaw, and it becomes a bit of an endless seesaw. So, but we can't afford to have this sort of a atmosphere or an ecosystem for disposal of commercial disputes. Now, why is that? Because in some quarters, questions are raised as to why must we have a separate procedural laws for commercial disputes alone? Why is it that they alone must be singled out for some positive treatment? The answer is very plain. There are very few ways in which the government can make money, and it is only if the government makes money, it can provide facilities to its citizen. It can work towards creating a welfare state. It can work towards eliminating poverty. For all this, the government needs money. Now, how is it to make this money? It can make this money by taxing subjects. It can make money by selling its assets, which is not considered to be a very prudent thing to do. It can make this money by printing notes. Now, that again is not a very prudent thing for any sovereign state to do. So you have very little options as to how a state can make money. So it really is not about giving some preferential treatment to commercial enterprises or to commercial transactions. It is all about facilitating a sovereign state to make more money so that it has the facility to establish a welfare state and also work towards elimination of poverty. Therefore, this view and attitude to say that commercial courts and commercial issues must not be given some special treatment is not something that is in welfare of the state itself. Therefore, the World Bank, you would have read about the report of the World Bank and the question marks that were raised about the methodology that has been followed to bring out these reports. But primarily the issue is the World Bank has been for a long time monitoring or rather appraising the state of various countries in their preparedness to deal with commercial causes, right? And frequently it brings out rankings. One thing I must tell you is these are largely what I call de jure rankings. These are not de facto rankings. De jure ranking is when a state brings out laws to deal with particular situations which the World Bank considers to be roadblock in commercial expansion, in the state doing well in commercial enterprises. Then the World Bank improves the ranking of a country. So in the last 4 to 5 years, we have brought out laws to deal with insolvency. We have brought out laws to deal with the corporate insolvency. We have brought out laws to deal with the arbitration and conciliation. We have improved the climate for international arbitrations. And in that line of legislation was the Commercial Codes Act, which have all helped to improve India's ranking in the world scenario. But the point happens to be just because a law is passed, it does not mean that it works very well. I always say that as far as the word act in this country is concerned, it works wonderfully as a noun, but is very difficult to achieve as a verb. I mean, what a situation when you want a law, the parliament passes a law or the state assemblies pass a law, which are then called acts. Now that is act in its noun form. For act to be in its effective in its verb form, the act must actually work. It must be useful to the subjects to which it applies. Therefore, it is essential that we have workable legislation. It becomes the joint endeavor of all of us to make these legislations work. In this line is the Commercial Courts Act. Thankfully, after the 2018 amendment, this long title of Commercial Courts, Commercial Divisions, and Commercial Appellate Courts Act has been shortened to just call this act a Commercial Courts Act. So this Commercial Courts Act is an infant, and it is the joint responsibility of the bar and bench to see that this infant grows up into a responsible citizen, which is going to be useful to both society and the state. And it is, as I said, therefore, the joint endeavor for all of us to make it work. And for us to make this legislation work, we need to understand what this legislation is all about. Now, why was there a separate, let's look at a bit of history. Why was there a law necessary to regulate commercial transactions? Now, before the Industrial Revolution in Europe primarily, which then spread to North America, there were laws relating to commerce. And there was a commercial revolution between 11th century AD and the 17th century AD. During the commercial revolution, there were a lot of legislations that were brought out by various countries to ensure primarily one thing, that any matter relating to a commercial cause must be disposed of within a sensible period of time. That was the emphasis of all commercial legislations that were brought out during what I would call the commercial revolution period. There were centers in Europe which specialized in the development of these laws, primarily Venice, Florence, Amsterdam, Genoa, and a few other cities. That is why, even Shakespeare named his play The Merchant of Venice, because a merchant of Venice was a very respectable figure in European society. He acted by his word. His word was his bond, which is then captured in that Merchant of Venice play, where he says, I have to offer this pound of flesh because I have signed a bond where I've said that if I do not discharge my contractual obligations, I will pay the price by offering a pound of flesh. So this is a very, very important aspect of the mercantile law. Also, when Venice was the center of trade in Europe, it was also the center of financial trade in Europe. It's only subsequently that London became the hub for financial transactions. For a very long time in history, Venice was the center of financial transactions, and much of this was regulated by maritime trade. Maritime trade was the focus of much of international trade in those times, because as you all know, we didn't have planes, we didn't have railways which connected continents, we didn't have motorways, we didn't have trucks. So all these facilities were not available. And if a cargo were a bulk cargo, the only way by which it could be transported across various nations, across the seas, was by ships. And many times these ships would dock at Venice in the morning and would leave by the evening for their other destinations. And therefore, if a dispute had to be settled, it had to be settled within a very, very short period of time. There was no time for the plaintiff to draft a plaint, file a plaint, for notice to be ordered, to the defendant to come onto the scene, for the defendant to file a written statement, and then a proof affidavit, cross-examination of proof affidavit. All this was simply not possible because litigation had to be concluded within a very short period of time. This gave rise to a body of law which was called lei mercatoria. So lei mercatoria in Europe is actually the beginning of the laws relating to commercial laws that we see today in the country. And much of what existed in lei mercatoria has been incorporated even in legislations that have been passed in recent time. For example, Law Mercatoria gave a great emphasis and great importance to usage of the trade. And many disputes had to be decided on the basis of usage of the trade. Now you find that reflected in the Arbitration and Conciliation Act, which in section 28 says that the arbitral tribunal has to decide a dispute on the basis of the contract, the agreement between the parties, that is, and also on trade usage. So it has been recognized seamlessly from possibly 500 years to 600 years back to the present times. So leg mercatoria ensured that disputes were resolved within the shortest possible time at the least expense in the most effective manner. And that was the advantage with the lay mercatoria. In India, it is not as if we did not have these facilities at all. In fact, in India, we had these facilities much before the Europeans had these facilities. We had what are called Shrenis, SHRENI. If you go into the web, Google, and if you Google Srini, you will come up with a lot of interesting information relating to Shrenis. And these were functional from 5th century BC. What were these Shrenis? Basically, Shrenis were guilds of merchants. And these guilds of merchants set rules for regulating various aspects of their trade. And there were different guilds of merchants for different types of trades. And each one would set its standards, would ensure that these standards were respected, would ensure that these standards were regulated, and the person who did not fall in line with this standard was excommunicated from the society. Thereafter, it became impossible for him to follow the trade. Interestingly, these guilds of merchants also protected intellectual property rights. Many of them were artisans who had knowledge of very intricate and very fine details relating to the execution of products in their line as artisans, and these need to be protected. And therefore, they had rules which regulated the manner in which a trade would be done. And these were extremely effective. They were so effective that before the British became a dominant power in India, if you take India's contribution to the GDP in about 1800, it was a whopping 23% of the world's GDP. We contributed 23% of the world's GDP. And between India and China, we contributed close to 50% of the world's GDP. Compare this with the figures when the British left us in 1947, we contributed hardly 2 to 3% of the world's GDP. This is because our traditional systems in which we did business, the traditional system in which the businesses themselves came to be regulated, the manner in which these came to be executed, all went a sea change after the British came in. Now, what is one single thing which the British did, which was different from the way that we had arranged our legal system? The one single thing which the British did, which completely turned our legal system topsy-turvy, was that they centralized the legal system. Everything became centralized in the presidency towns. Of course, there were courts at the lower level, but from there, an appeal would lay to the presidency towns. That's where most aspects got to be decided. Whereas in our traditional systems, traditional legal systems, much came to be decided at the level of the panchayat. There was no necessity for many of these disputes to travel anywhere other than the panchayat, because a large percentage of these disputes were satisfactorily settled at the level of the panchayat. There is a 1935 case law by the Privy Council which says, which is a matter which arose from the Madras High Court, where the Privy Council says this is a very sensible system of justicing, and the British must ensure that they do not interfere with these systems of justicing. That's how effective they were. And therefore, this traditional system of justicing came to be completely inverted, which is a change. Since we have been used to this system for the last nearly 2000 years, this change, we were not able to adapt to it very easily. And therefore, if you think that backlogs are a system of the present day. Please read 1920, 1930 judgments of the High Court. There is a lament in the 1920, 1930 judgments of at least the Madras High Court where they say the backlogs in this court are ballooning. So therefore, our problem was that these were systems that that we could be ill adapted to, and that resulted in the 3 crore pendency of cases that we have in various courts today. But we can't afford to have that in respect of commercial disputes, because commercial disputes, as I said, the ideal is it must be decided the same day. If you can't reach that ideal, it must at least be decided in the period of 6 months. There is a study which the World Bank has done, which said that when you seek enforcement of contract in Indian courts, the barest minimum time it takes is 4 years for a matter to be decided. Many of you who have done matters, civil matters relating to contracts will know that in respect of a large number of cases, this is not true. It drags on for much longer periods than this 4 years which the World Bank is talking about. But that is the shortest period of time which in which, on an average, a commercial dispute gets to be decided by Indian courts. It is therefore became necessary for Indian courts to come up with a legislation that will deal with disputes and will deal with them effectively and will deal with them within a reasonable period of time. Also, by 2000, what was happening was that in respect of many disputes where India and Indian courts must have jurisdiction, slowly this jurisdiction was being whittled down. It was being encroached on. It was being eaten away by various courts. And these courts said that Indian courts are not very effective in treating these legislations, in these litigations, and ensuring speedy disposal of cases. And therefore, they invoked the doctrine of just convenience and started deciding matters which should have ideally been decided by the Indian courts. Therefore, the Law Commission in 2003 came out with the report as to how to reform the civil procedure system and to ensure speedy disposal of the cases. From 2003 till 2009, these suggestions lay dormant, as with many suggestions of the Law Commission. But in 2009, a bill was placed before the Parliament suggesting changes to the civil procedure system and talking about the establishment of commercial courts. But that came in for a huge volley of criticism from the opposition, which said one of the things that the bill attempted to do was to make every high court center of commercial litigation in that state. Now, this is what the opposition did not find as a very welcome move, and they said that this was concentrating commercial litigation in courts which were already overburdened. And they said there's no point in your doing it. Please look at the statistics for all the courts. They are already overburdened. So there is no point in entrusting them with more and more cases. And this was a primary point of contention in respect of those commercial courts. And therefore, that did not see the light of the day. Also, the argument was that this was a bit of an elitist piece of legislation because matters were taken away from the jurisdiction of lower courts. Higher values enjoyed the facility of commercial courts. Claims with lower values did not enjoy that facility. It is therefore that that legislation which was proposed in 2009 did not get to be passed. Subsequently, after the present dispensation took over in 2014, primarily on account of the efforts of late lamented Mr. Arun Jaitley, the commercial a sensible legislation which will take care of commercial disputes. And thus the Law Commission proposed the passing of the Commercial Courts Act. Now, the Law Commission report 253rd Law Commission report went into various factors. It also studied the scenario in various other countries. In fact, even the 2003 Law Commission report did that. So they said, let us not repeat that exercise. They incorporated all the observations about how effectively commercial courts are functioning in various parts of the world, and then said, let's have a legislation which is sensible, which percolates down to the district court levels, which is not top heavy, and which can really produce results. Now, during that exercise, the Law Commission also found that, very interestingly, that this is not a problem only had also faced a similar conundrum. And there was in England in 1997, there was a committee which was established under Lord Woolf to go into the working of civil courts and to make recommendations for reforming them. This is what Lord Woolf observes in that report. He says these are what he recounts as being the problems of the civil justice system in England. He says it is too expensive in that the costs often exceed the value of the claim, a very common feature in India too slow in bringing cases to a conclusion, and too unequal. There is a lack of equality between the powerful, wealthy litigant and the under-resourced litigant. It is too uncertain. The difficulty of forecasting what litigation will cost and how long it will take will last induces the fear of the unknown. It is incomprehensible to many litigants, and above all, it is too fragmented in the way it is organized, since there is no one with a clear overall responsibility for the administration of civil justice, and too adversarial, as cases are run by the parties, not by the courts, and the rules of courts all too often are ignored by the parties and not enforced by the courts. So this is a list of the problems of the civil justice system in England. And as I read it, you would have recognized that many of these problems also visit the civil justice system in India. So what did Lord Woolf recommend? He said that you must have a system which is just in the results it delivers. It is fair in the way it treats litigants. It offers appropriate procedures at a reasonable cost. It deals with cases with reasonable speed. It is understandable to those who use it. It is responsive to the needs of those who use it. It provides much certainty as the nature of particular cases allows. And lastly, it is effective because it is adequately resourced and organized. So this is what he suggested as the prescription for curing the ill which the civil justice system suffers from. On the basis of that, England also brought out a legislation to regulate its commercial disputes. Now, this is what went into the making of the Law Commission report, which is the 253rd Law Commission report. Now, after having said this, that is the theory. As I said, there are three parts to my speech: the theory, procedure, and practice. So I have now dealt with the theory. Why did we need a new legislation to take care of the manner in which commercial litigation will be handled in this country? Now, let me come to the second part. What is the procedure that the Law Commission said should be followed, and what are the changes that it suggested? Let me go through that to tell you. After I finish that, then I'll come to the practice, which is the provisions of the Commercial Courts Act itself. That is how this procedure actually gets applied in the law. So as far as the procedure is concerned, these are the changes which the Law Commission recommended. Not all of them have been adopted. there are totally 20 recommendations which the Law Commission made. Not all of them have been adopted, but I'll tell you what has been adopted and what has not been adopted. The first that the Law Commission recommended is to provide a period of 30 days to the defendants to file their written statement and an additional 90 days subject to the satisfaction of the court on the payment of costs. Now, this was incorporated and changes were made to Order 5, Rule 1.1 and Order 8, Rule 1. Therefore, today, unfortunately, as you all know, in the Salem Bar Association case, the Supreme Court ruled that all the new stipulations with regard to time in the Code of Civil Procedure were merely recommendatory and not mandatory. So the massive efforts which the Parliament did to reform the civil litigation in the country by bringing out changes that required time-bound action under the amended provisions of the CPC proved completely futile because the Supreme Court said that these recommendations are merely recommendatory and not mandatory. Now that is dealt with by this Law Commission report, which says that you must make amendments to Order 5 Rule 1.1 and Order 8 Rule 1 to stipulate an inflexible period of time within which pleadings have to be completed. Primarily, the written statement has to be filed. Now that has come to be adopted in the new Act. The second aspect of procedure, disclosure and inspection norms under Order 11 is to be allowed to allow parties to complete the discovery of all documents effectively and to apply to all documents photocopies of the documents, power, etc., etc. So this amendment to Order 11 also came to be accepted by the Parliament, and that has been incorporated in the Commercial Codes Act. The third is it brought out a new procedure for summary judgments. All of us know, who have been practicing civil law, know that as far as summary suits are concerned, are suits which a plaintiff files to get a summary decree. Now, what is the primary difference which the provisions of the Commercial Codes Act makes as to this concept? It is that the defendant can also take out an application for dismissal of a suit in a summary manner on the basis that it discloses no cause of action. So that is a real revolution, and the court can decide this issue without being bound by the provisions of the CPC. Therefore, a new procedure for summary judgment was introduced to decide a claim pertaining to any commercial dispute without recording oral evidence. So summary suit came to be incorporated in Order 13A of the Commercial Codes Act. Then a new cost regime of cost to follow event to be introduced. Now this is a very important change, as I have been part of the Law Commission deliberations with regard to the Arbitration Conciliation Act also. We have incorporated it. We had recommended the incorporation of it in the Arbitration Conciliation Act. Unfortunately, what happens in India, you file a frivolous suit and that suit is contested for several years, and at the end of it, even if the court dismisses, it gives you a paltry cost. So what happens to the poor person against whom that litigation has been filed and who's been forced to contest it for many years, who has been forced to engage advocates to contest his suits, who has spent money on coming to courts innumerable times, who has lost opportunities on account of the pendency of the matter? All these have to be compensated. And today, by amendment to Section 35 of the CPC, these costs have become realistic. Then changes to the procedure where interest is sought in a suit and to the filing of evidence was also recommended, and that has now come to be incorporated in Order 6, Rule 15A of the Commercial Codes Act. The other important change that the Act brings about is the system of case management. We have no concept of case management at all in our civil system. Not that we have a great system as far as criminal cases are concerned, but in civil cases it is completely absent. So this Act, through the provisions of Order 15A, introduces a procedure for case management where after the plaint is filed, the parties are encouraged to, they are not even, they are obliged, encouraged is not the right word, they are obliged to, uh, to come up with a scheme as to what would be done when. And this is some sort of an inflexible scheme that both parties agree to, and the suit proceeds on that basis. Dates are fixed, issues are framed, parties are told, parties are asked for a list of witnesses, they are asked when, how long it will take to cross-examine each of these witnesses. Everything is decided upfront, which makes the disposal of the cases so much more easier. Then time-bound oral arguments to be supplemented with written submissions. This again is a very important innovative step that has been taken, that has been introduced under the provisions of Order 18 Rule 3A. This is also another recommendation which the Law Commission made, which has been introduced. Then, eighth recommendation which the Law Commission made is courts to be empowered to control, redact, or reject evidence for reasons to be recorded in writing. If the court feels that a particular evidence is completely irrelevant and is completely unnecessary, the court need not wait till the end of the trial. At the time when it is writing its judgment, during the process of trial of the suit itself, on account of the acceptance of this submission, of this recommendation of the Law Commission and its introduction in Order 15A Rule 6, this has now been made a part of the Commercial Codes Act. Then time-bound delivery of judgment has once again been introduced, and the judgment has to be delivered within 90 days from the conclusion of arguments. This recommendation has also been accepted under Order 20 Rule 1. Then for suits that have been transferred to the commercial court or commercial division, the procedural provisions will be applicable only from the point in the trial at which they have been transferred. You must understand a distinction between a suit that is filed and being pursued and an appeal. Please understand, it is only the commercial causes suits which will be transferred. Appeals are not going to be transferred. Appeals will continue to stay in their appellate courts of respective jurisdiction, and in respect of those suits that are transferred, the procedures that are stipulated through the amended provisions of the Commercial Codes Act will apply from the time the suit is transferred, and that has been made possible by its introduction in section 15(3) of the Commercial Codes Act. Procedural rules to be supplemented by practice directions. This is a very, very salutary provisions. The High Court, I don't know how many High Courts, I don't know whether your High Court has come up with practice directions to regulate the working of the commercial courts. If they have not been done, I think the bar must demand that these practice directions that these practice directions, there has to be a different set of practice directions, at least as far as the Madras High Court is concerned, because Madras High Court has letters patent jurisdiction. Therefore, the practice directions that will be applicable to the High Court in exercise of the jurisdiction is different from the practice directions that will apply to civil courts. I don't know whether a similar system exists in other parts of the country. There are only 5 courts, High Courts in the country, which have ordinary original civil jurisdiction. These are Madras High Court, Calcutta High Court, Bombay High Court, Delhi High Court, and Himachal Pradesh High Court. Therefore, in respect of these High Courts, at least, there has to be 2 different set of practice directions. For example, you take the Madras High Court, there is no concept of a originating summons in a civil, in a district court, right? Even in the Madras High Court, that has been whittled down. But I'm just pointing out the difference in procedure as applicable. For example, judges summons, master summons. These are procedures that we have in the Madras High Court in exercise of its powers under letters patent, which we don't have in the civil court. So if you're going to issue practice directions, you need 2 sets of practice directions, one for the High Court and one for the civil court, at least in courts like Madras High Court, which has original jurisdiction. But what is important is that these practice directions can be extremely useful. And since these are being issued by the High Court, under the authority vested in them under section 18 of the Act, it is quite unnecessary for us to go to the legislature every time we want to make a change. If some direction does not work with you amend it, and the process of amendment of these practice directions becomes so much more easy. It is essential that every court must have these practice directions, and they must be displayed in the website of the respective high courts. Um, the commercial division and the courts are to take advantage of the new infrastructure wherever possible, and are to be run as model courts along the guidelines laid down in the model court report. That has now been incorporated under section 19, and separate infrastructural facilities have to be created for this court. I'm going to come to that. Unfortunately, many courts have not done that. No special technologically upgraded infrastructure has been made available. This again is one of the duties of the bar to demand that it happens, and it is only if we demand that change is going to happen. Then the 13th recommendation says that the National Judicial Academy and the state judicial academies shall create necessary facilities for training and continuous education of judges of the commercial courts. Once again, legislatively, that requirement has been incorporated under section 20, but again, unfortunately, there is very little training that is happening in various high courts to train the judges with regard to disposal of cases under the Commercial Courts Act. So this again can happen only through demands from the bar. Then the 14th recommendation says all applications or appeals in international commercial arbitration concerning commercial disputes of specified value that have been filed in a high court are to be heard and disposed of by the commercial appellate division of the high court where such commercial appellate division has been constituted. This has been accepted and incorporated under section 10. So the jurisdiction in respect of international commercial disputes rests with the commercial courts at the level of the district courts, and where there is a high court, it will be vested with the commercial division and the commercial appellate division of the high courts. That is now part of section 10 of the Commercial Courts Act. The 15th in domestic arbitrations concerning commercial disputes of specified value that have been filed on the original side of the High Court will be heard and disposed of by the Commercial Appellate Division of the High Court where such Commercial Appellate Division has been constituted. That again has been incorporated under section 713. So all commercial disputes matter now come before the commercial division of the respective high courts, or they should go to the district court. All applications or appeals in domestic arbitrations concerning commercial disputes of specified value that would ordinarily lie in civil court will be heard and disposed of by the commercial court exercising territorial jurisdiction over such arbitration. That has also been accepted and made part of section 11. So section 10, section 11 and section 13 deal with issues of which courts. In the first place, all arbitration matters, the jurisdiction has been vested in commercial courts. Then within that hierarchy, international commercial arbitrations would go to the commercial divisions and would go to the commercial appellate divisions. And as far as the district court is concerned, domestic arbitrations, the place of the forum where it will go has been stipulated under the provisions of the Commercial Courts Act. All appeals preferred against any decree or order of the commercial court shall be heard and disposed of by the commercial appellate division of the relevant high court, preferably within a period of 6 months from the date of filing of such for the disposal of appeals. As I said earlier, that has now been incorporated into section 40 of the Commercial Courts Act. But as I said earlier, there is no transfer of the appeal from existing court. Even if they are with regard to a commercial cause, they are not being transferred to the commercial appellate division. They continue to remain where they were, which I think is a matter that must be addressed, and the bar must call for transfer of these matters also to the commercial appellate divisions of the High Court. Next, we come to a very important recommendation, which is recommendation 18. No civil revision application or petition shall be entertained against any interlocutory order of the commercial court, including an order on the issue of jurisdiction. That's a very, very important provision, because as you all know, as many of us who have operated the civil justice system, we know by the time the suit is disposed of, there are innumerable civil revisions filed against any order that is passed in any matter, and ultimately it prolongs the disposal of the case. Now, under the provisions of the Commercial Courts Act, as it stands amended by the 2018 Act, there are 4 levels. The commercial court below the district court level, which has jurisdiction starting from 3 lakhs, but till what extent it will go, the state governments have to stipulate. Then you have commercial disputes, commercial courts at the district court level. And then in respect of high courts, those high courts which have original side jurisdiction, commercial division in the high court. And then you have a high commercial appellate division. So these are the 4 hierarchies. Many states have not created courts below the district court level, right? Many states have not stipulated what the jurisdiction of courts below the district court level will have. So today, that initial rung doesn't exist. Then you have district court level and commercial divisions, and then the commercial appellate division. If an order gets to be passed by a court which is below the district court level, an appeal lies to the district court. If an order is passed by a court at the district court level, an appeal lies to the appellate division in the high court. If an order comes to be passed by the commercial division in a high court, that gets then the appeal will lie to the appellate division in the high court. So this is the hierarchy. What is important is, beyond one appeal, none of these provisions have a provision for a second appeal. There is no provision for a second appeal in respect of any order that is passed by any of these courts under the Commercial Courts Act. It is of course possible that if you file an application before the district court and there's an order passed by the court below the district court and an order is passed by the district court, high court can still exercise their jurisdiction under Article 227 of the Constitution. As that is part of the constitutional provision, nobody can take it away, but still it is hoped that the courts, high courts, will be sparing in interfering with orders that are passed by the district courts, and likewise the Supreme Court will be slow in interfering with orders that are being passed by either the commercial appellate division in exercise of its power over the district court, or in exercise of its power over the commercial division of the high court. These are very important stipulations. For the first time, we have a system that reduces the number of appeals to just one. And if the Commercial Courts Act is to be a success, high courts must ensure that this rule is not violated, and that innumerable revision petitions, appeals are not filed against orders passed in interlocutory applications. This is a very, very salutary provision which we will have to keep in mind. Then two other, I'm now reading the 19th and 20th recommendations of the Law Commission, which have not been incorporated. They are not part of the Commercial Courts Act, but we hope that in due course of time, these will also be given importance and incorporated. One is, they say, the Law Commission said that writ petitions and writ appeals, for example, take a tender matter. Some writ petition is filed in respect of a tender matter and the matter gets stuck in courts. Now, the Law Commission recommendation was that even writ petitions must be posted before the commercial courts, and appeals from that must go to the commercial appellate court. That has not been given effect to, but it is still open to the Chief Justice, because after all, the Chief Justice is the master of the rolls in all the high courts. So it is still left to him to designate commercial courts before which writ petitions relating to commercial matters can be posted. But that is that is a change, that is a reform must happen at the level of every high court. But the law itself has not made provisions for that. The last recommendation of the Law Commission was the Law Commission proposes a relook of the court fee regime by the state governments in the light of their legislative domain under entry 3, list 2 of the 7th schedule of the Constitution. Here, the Law Commission has recommended wide-ranging reforms with regard to court fees. It says, like Singapore High Court. In Singapore High Court, your court fee, you pay an initial amount. Then there is a record of how much of the court's time you take, and a final decree will be passed only after you make the payment in respect of whatever time you have taken, which has now been, which is then computed, and a demand is made for you for payment of a further court fee. Only if that is done, then will a decree be passed. Something like that was recommended by the Law Commission. Of course, those will have to come as amendments to the court fees of each state. That unfortunately has not happened. Possibly over a period of time, if there is greater pressure from the members of the bar, that change can happen, but that has not materialized into changes with regard to the provisions of the commercial code side. So I have now dealt with theory, I have dealt with the procedure. Now I am coming to the third aspect, which is the practice, and practice will depend upon what the Act itself says. So I'm going to briefly go through the provisions of the Act to give you an idea as to how these procedures will reach a level of congruence with practice in commercial courts on the basis of what the Act says. Firstly, the Act in section 2 defines what is a commercial cost. There are primarily 21 different types of transactions which have got classified as commercial disputes. It is only in respect, so that is the practice. What is the practice? The practice is that in respect of these 21 classes of disputes alone, the commercial courts will have jurisdiction, and each of these are designated or are stipulated in section 2 of the Act. Lastly, in clause 22 is a provision under which the central government is authorized to stipulate any further transaction as one falling within the definition of a commercial dispute. And then section 3 talks about constitution of commercial courts. I have already explained to you the 4 levels at which the commercial courts must be constituted. There is another point which the bar has to take into consideration at this point of time if we are to make sense of this legislation, and that is, what are the commercial courts that have currently been established? The commercial courts that have been established in very many states are merely redesignation of the existing district court and the principal district judges court into a commercial court. This completely defeats the provisions of the Act. In fact, I have filed a public interest litigation which is likely to come up in 1 or 2 weeks. And before that, we have served notices on all state governments asking them to constitute specific commercial courts, which none of the state governments have done, except I think Delhi. Presently, it is only the existing principal district judge who is classified as a commercial court. The entire purpose gets defeated. This Act will work only if you create separate cadres. The selection must be separate. These are persons who must have acquaintance with the law relating to commerce. They must have some experience in dealing with commercial matters. It is only such people who must be appointed as judges of commercial courts, and it is only then that this Act should be effective. I don't know, all of you, I'm sure, would have gone to the court of a principal district judge. Just look at the innumerable number of matters that gets posted before him. He deals with bail applications. he deals with criminal appeals, he deals with matters under the Motor Accidents Act, he deals with appeals in matrimonial matters, he has original jurisdiction in half a dozen different legislations, he takes up appeals against civil suits, final decrees. So the work of a district judge is mind-boggling. And just because you are able to, shift dirty linen from one basket to another basket, the linen will not become clean. You have to clean the linen, right? So the present attempt by all state governments to merely redesignate principal district judges to be commercial courts is completely retrograde. It is not going to give us any relief at all. Therefore, at every level, lawyers must demand that a separate cadre of commercial courts be created. The state governments must be persuaded to designate and create separate cadres for recruitment of district judges. These must be through separate examinations, separate interviews, and it is only then that it can work. The Law Commission has also recommended that in respect of commercial divisions, even in the High Court or the Commercial Appellate Division, please do not change a designated judge from that jurisdiction for at least a period of 2 years. We have the system in the first place. I think in many courts, the trial is not held before the judge who ultimately gets to write the judgment. So things like demeanor of the witnesses, answer to questions put in cross-examination, reactions to documents that are put to witnesses, all these have become meaningless. All these are reduced to a bunch of papers, and we file a paper book and argue on the basis of that paper book. Therefore, the purpose of trial itself is lost in many of the civil litigations. It is going to get worse because we know that we actually see that a trial passes through 4 or 5 judges before ultimately a judge passes an order. Now that is extremely retrograde. That is why I said practice before commercial courts is different from the mere procedure. These are all aspects relating to practice, which the bar must take note of and must demand changes. So constitution of commercial courts is what section 3 deals with. Section 3A deals with designation of commercial appellate courts. That is when a district court has a court below the district court constituted as a court of first instance in commercial courts, then the district court itself gets designated as the commercial appellate courts. And then you have the constitution of the commercial division of the High Court. This will apply only to the 5 high courts, which I told you about earlier. Then the constitution of the commercial appellate division, which becomes the sort of an apex court dealing with all appeals coming from the lower level, which is the district court level, to the High Court. Then you have the jurisdiction of commercial courts to try all suits and applications relating to a commercial dispute of a specified value arising out of the entire territory of the state over which it has been vested with territorial jurisdiction. So that completely defines the jurisdiction of these commercial courts. Then the jurisdiction of commercial divisions of the High Court, you must constantly keep reminding yourself that there are these 4 different classes of courts which the Commercial Courts Act talks about, the Commercial Courts Act has established, and the jurisdiction of each of them must be clear in your mind before you start practicing before these courts. Bar against revision application is dealt with by section 8. I told you when we talked about procedure that this innumerable number of CRPs arising from interlocutory applications has been the cause of much agony in the functioning of our civil court system. So that is taken care of by section 8. Section 9, transfer of suit of counterclaim in a commercial dispute is of a specified value. Now this has been omitted by the 2018 amendment because now even starting from 3 lakhs, courts have jurisdiction. So it is hoped that all matters if it is a commercial cause, will undoubtedly come before a commercial court. Into what slot it will fit will depend upon the claim that is being made, and it is on that basis these commercial courts will work. Then section 10, jurisdiction in respect of arbitration matters, that also I explained to you, two classes of arbitrations: international commercial arbitration and domestic arbitrations. What applications will go where is stipulated in section 10 of the Commercial Courts Act. Bar of jurisdiction of commercial courts and commercial divisions. A commercial court or a commercial judge shall not entertain or decide any suit application to any commercial dispute in respect of which the jurisdiction of the civil court is either expressly or impliedly barred. There are certain legislations which rule out the jurisdiction of civil courts completely. For example, if you take the Chit Funds Act, you have the registrar of chit funds. There is a hierarchy of courts that is created in respect of matters which are stipulated to be within the jurisdiction of tribunals created under the Chit Funds Act. It is only that authority who can have jurisdiction. Therefore, even though a particular transaction may fall within the definition of a commercial dispute, for example, take chit funds, since it's a financial matter, it can still fall within the jurisdiction of the commercial courts, but still courts do not take up the matter for adjudication, because there is a specific act that has been created and a hierarchy of authorities have been entrusted with the power of dealing with disputes under that act, and therefore it is only those courts that will have jurisdiction. Then most important is determination of specified value. Many times we know that litigations get caught up in this quandary of what the valuation is, and once again there are CRPs filed, applications filed for dismissal, against which one CRP goes, and then right up to the Supreme Court, and then it comes back. All this is sought to be avoided, and the Law Commission had also gone into how the specified value is to be calculated, and that is calculated by the provisions of section 12 of the Commercial Courts Act. Then 12A is a very important provision relating to pre-institution for mediation and settlement. Now, this is a very salutary provision. It has to be applied in the manner in which it is contemplated. I have this very uneasy feeling with regard to alternate dispute resolution in this country, because to me, this alternate dispute resolution has not evolved very well in our country. Because though we call it the alternate dispute resolution system, in some form or other, the control over that litigation is still retained by either the courts or the government authorities. Take government contracts. In many of the government contracts, who is the person who is appointed to be an arbitrator? An engineer of the company. Of course, there are now rulings of the Supreme Court and provisions of the 6th and 7th schedule of the Arbitration Conciliation Act, which rule out the possibility of any of these persons being the arbitrator. But still, unfortunately, there is a mindset which says that our own people will be the arbitrator, the government servants will be the arbitrators in various disputes. So the government does not free the litigation from the control of the government itself. Courts create, well, while it is all very well intentioned, still courts itself have the court annexed mediation, court annexed arbitration. If you have court annexed mediation, court annexed arbitration, my simple question is, what is alternate about it? Alternate system of dispute resolution is you must be alternate to either the government or the court. It must be handled by individuals, it must be handled by entities in society which can come together to form institutions. For example, in Madras, Mr. Arvind Dattar, myself, members representing chartered accountants, members representing business interests, we have all come together to form the Nani Palkiwala Arbitration Center. Now, that is an independent institution. You must have these arbitral institutions. You have the ICC in Paris, you have the London Arbitration Center, you have the Singapore International Arbitration Center. These are all completely free of government control. When SIAC was established, the Singapore government came in, gave them space, gave them funding, and encouraged them to establish the resources for the center. Like that, we must have in every state. Lawyers must get together and with the help of industry and other professionals must establish independent arbitration centers, independent mediation centers. Unfortunately, mediation and arbitration in this country is not going to be effective as an alternate dispute resolution centers till you have these alternate dispute resolution institutes which are independent of the state or the government. But anyway, the provision itself is laudable and I hope it will work well. But that, at least to my mind, is possible only if you have independent authorities functioning as alternate dispute resolution centers. Section 13 deals from decrees of commercial courts and commercial division. There is a bit of a problem with the wordings in this section because it says any person aggrieved by the judgment or order of a commercial court. There is no problem as far as the order is concerned. It is regulated by the provisions of Order 43 CPC, read with the provisions, other provisions of the CPC. But when it comes to judgment, it is a bit of a quandary. Now, what is a judgment? Judgment is not defined under the Commercial Codes Act. Judgment is, however, defined under the CPC. And CPC says that a judgment is the reasons that are given in support of a decree. Now, that's not vastly helpful. You have the very famous case of Shah Babulal Kimji case, which was decided by the Supreme Court as to what a judgment is. The Supreme Court says every interlocutory application is not a judgment, but those interlocutory applications that decide the rights of parties conclusively are judgments. But that is in reference to the word judgment under the letters patent. Are commercial courts going to adopt the same definition of judgment or that meaning of judgment? If they are going to adopt that meaning of judgment, you are going to have several appeals to the various authorities under the provisions of the Commercial Codes Act. So I think we'll have to wait for some time to see some clarity. I have argued two cases before the Madras High Court with regard to what this judgment means. And in one judgment with regard to Graziani case, I have the Madras High Court has agreed with me that the word judgment in section 13 must be the same as the word judgment in the letters patent, but we need to see how that is going to evolve. Then section 14 talks about expeditious disposal of appeals. As I said, appeals are not being transferred. The bar must demand that appeals also get transferred to these appellate courts. Section 15 talks about transfer of pending cases. And as I said, only the existing civil suits get to be transferred. Section 15.3 makes it very clear that the procedure stipulated under the Act will start applying only after the suit is transferred. And therefore, there is a bit of a confusion with regard to that because from when does the time start for filing your written statement? So after the matter is transferred to the commercial court must then pass an order that from this moment, the provisions of the Commercial Codes Act apply. And if in a particular suit, a written statement has not been filed till then the 120-day period will start ticking from that time. So that provision will have to be made as part, those changes will have to be made. Then the amendments to the Code of Civil Procedure, which I talked to you about, which have been accepted. And also it says when there is going to be a dispute between the provisions of the Commercial Codes Act and the CPC or the letters patent, it is a provision of the Commercial Codes Act that will apply. Section 17 is a very important section with regard to collection of disclosure of data by commercial courts. It is obligatory under the provisions of this Act for every High Court to display in its website details of how many commercial cases have been filed, how many have been disposed, how many are pending. But unfortunately, a study which is done by an organization called VIDI shows only 8 High Courts are displaying this information. And even of the 8, only the Delhi High Court is displaying the information as it is required to be displayed under the provisions of the commercial. There are separate rules which regulate the manner in which these rules must be displayed, but unfortunately that is not being followed. That again is something for the bar, and the bar associations must demand that the provisions of section 17 must be complied with. Section 18, power to lay down the practice directions. with regard to the commercial codes, which I told you about. Section 19, once again, I dealt with that, infrastructure and facilities. The bar must ask for separate infrastructure facilities to be created for these commercial codes. Section 20 talks about training on continuous education, which again I dealt with briefly when I was talking to you about the procedure. 21 says that the act is to have overriding effect over the provisions of any other act. 21A gives the power of central government to make rules to regulate the various aspects relating to the working of the commercial codes. Section 22 is the power to remove difficulties, and 23 is the provision relating to repeals and savings. So this, in brief, is how the Commercial Codes Act is expected to function. And as I said, it can function wonderfully provided all of us play our part. And it is extremely important for the economic well-being of the country. Only if economy thrives in this country will we become an attractive destination. Only if we become an attractive destination is it possible for the country to generate revenue to meet its welfare state obligations and also work towards elimination of poverty. Thank you for giving me this opportunity. I'll be quite glad to answer any question that you would want me to answer.
Yes, sir. The as we say, the session is spot on. We got all the insights in a approximately 1 hour 15 minutes. The capsule as to what is the theory, what is the practice, and what is the procedure. We will be taking the questions. So this is by Srinivas Mulguri. Please elaborate the distinction between a regular civil suit and a commercial dispute.
Firstly, the distinction is, does your suit fall within the category, the specified category of a commercial dispute? It gets categorized as a commercial dispute if you fall within one of the 21 categories stated in the Act. If you don't, it is an ordinary civil suit. Once you get classified as a commercial dispute, then the next question is, in which slot will you fit? As I said, at the civil court, at the trial court level, you have the district court and courts lesser than the district court. So there has to be a determination of which slot you will fill. And where the civil court jurisdiction is that of the High Court, once again, within, for example, in Madras, if the Madras High Court has jurisdiction, Madras High Court jurisdiction is only above 1 crore. If there is going to be a court below that, that has to be constituted, and it is to that court the matters will go. So the first is deciding whether it is a commercial cause. Second, after that has been done, deciding whether it is will be a specified, what is the specified value for the purpose of jurisdiction. And thirdly is territorial jurisdiction. And thereafter, the entire provisions of the Act will apply with regard to procedure. So in respect of the subject matter is only those which are commercial disputes which will come within the jurisdiction of commercial courts. In respect of procedure, once that is determined and territorial and pecuniary jurisdiction gets to be crystallized, then the procedure under the Commercial Codes Act will apply. This is a very simple process by which the Act will apply to matters before the commercial court.
The next question is by Murali. It says, if the amount in dispute is less than 3 lakhs, however, with the interest, the amount crosses 3 lakhs, then where will the suit lie?
You have the answer in section 12. Section 12 says how the specified value has to be calculated. You have to apply section 12 and determine whether it should go to an ordinary civil court since it is less than 3 lakhs, or whether it will come to the commercial courts. So the provisions of section 12 on a case-to-case basis will have to be applied to determine the value. And there is far more clarity in section 12 rather than in many of the case laws which have gone into issues relating to pecuniary jurisdiction. It's a very simple formula that is to be applied. That formula has to be applied to determine whether the matter will go before the district court or before a non-commercial court, or whether it will come before a commercial court.
So I've unmuted Ramnath. he wants to ask a question.
Sir, very good evening, sir. Very good evening, Mr. Vikas.
Yeah.
Sir, this is a question regarding the transfer of the suit before the commercial courts. Sir, sir, can you hear me?
Yeah, I can.
Sir, suppose if the suit is in a parted stage and if it is transferred to the commercial court, whether the trial has to commence afresh or...
No. No, that is why the Act itself very clearly says that the provisions of the Act will apply from the time the suit is transferred. If you come to section 15.3, where any suit or application, including an application under the arbitration relating to a commercial dispute, shall stand transferred to the commercial division or commercial court under subsection. The provisions of this Act shall apply to those procedures that were not complete at the time of transfer. So only in respect of those procedures that are incomplete, the provisions of the Commercial Courts Act will apply. It does not require that you start the trial from the word go.
Say, suppose some of the witnesses have been examined and they have deposed, and I want to recall them before the commercial courts.
You will have to do it in line with the existing provisions. That is, you will have to file a recall application, and your recall application will be treated as a recall application under the Commercial Courts Act. Its merits will be considered on the basis of the procedure stipulated under that Act, and then the court will decide whether that application can be allowed or dismissed.
Thanks a lot, sir.
So this is by Namish Sodhi. A civil suit was instituted by the plaintiff for a recovery of rupees 2 lakhs in a civil court. However, the counterclaim filed by the defendant is for 10 lakhs. Would the case automatically be transferred to commercial courts, or do we have to move an application in this regard? And in this case, does the provision of section 12A become mandatory?
If both, see, that is why section 9 provided for that. But section 9, now section 9 got deleted. This is in fact one lacuna in the Act to my mind, because this is exactly the type of case where section 9 would have normally applied. But they thought that since we are reducing the level to rupees 3 lakhs, now everything that falls within the definition of a commercial dispute would automatically go on to the commercial courts. But a case like this is a case where it should come only before the commercial courts, because the value of the counterclaim is 10 lakhs. And you have to move an application to transfer the suit to the commercial court.
So 1 minute. Sir, are the cases related to GST are also dealt in commercial courts?
No, it is not, because of section 11 of the Commercial Courts Act, which says there is a bar of jurisdiction with regard to cases which are dealt with by other tribunals. GST Act itself has a hierarchy of authorities before whom matters relating to GST will go, and therefore it is only before them these matters will go. That's why section 11 will apply.
So this is by Pawan. What's the time limit within which a commercial dispute ought to be invariably decided in a trial court?
See, the hope is that it will be disposed of expeditiously, because for every aspect of it, there are some time frames that are stipulated, and much of it will depend upon the time frame that is going to be given to you in the case management hearing, because we can't put all suits in the same category. So crucial to the time for disposal of a case is what is going to happen in the case management hearing. So if it is a very complex case, let's say it involves some 400 documents on the plaintiff side, some 500 documents on the defendant side, obviously you can't expect that matter to be decided within a period of 2 to 3 months. There the court can grant a longer period within which the disposal of the case happens. But if it is a very simple matter, it's a short claim, and the court is not able to see much of a defense, the matter can even be over in 3 to 4 months. So what will decide how long the suit will take is the time to be fixed by the court in the case management here.
Mr. K. Sankaran asks whether pre-mediation is a mandatory requirement under this Act.
Yes, pre-mediation is mandatory if the suit does not have any interim prayer. If the suit has, let us say, injunction application The court can't say that I will take up the injunction application after I dispose of the after the pre-mediation is over. So in respect of matters where there is a provision for interim relief, that will be heard. But if your suit has no prayer for any interim relief, then it has to go for pre-mediation before the matter is taken up for any further hearing.
Another question I asked from that, do you find that in a commercial court cases, there would be, I don't think there would be any case as such where injunction would not be required. Let's assume that there invariably will be that he should not dispose of his movable and immovable property.
Yeah. Lawyer's ingenuity, even if there is no prayer for injunction, he will file some receiver application. They will file some other commissioner to be appointed to take note of the features of some property. So some interim application will be filed by lawyers. So I think the class of cases where, unless it is a pure money suit, and you can hope to, even there, they will ask for some relief restraining him from alienating some property.
That's what I'm saying.
Very rarely do you have.
Just like in DRT, we say that we move an application to the effect that movable and immovable property should not be disposed of. So what is your opinion? Yeah.
So very rarely will you have a suit which does not have an interlocutory application.
This is by Sameer S. Shah. What is your opinion for an extension of time for filing a written statement beyond the prescribed limit, particularly
beyond the
when there
prescribed
is
limit,
real hardship or inability to file a written statement?
Whatever is the reason, the court today has no power to extend the period beyond the time that is stipulated in the Act. And if you file an application, that just will get dismissed. And even if the court were to sympathize with you, there is nothing that can be done. But as you all know, in a suit, the plaintiff has to make out a case. Just because you don't file a written statement, it is not that a court is going to grant a decree. So you will have to utilize, if you have a really good case, you will have to utilize your opportunity given to cross-examine the plaintiff to show that he is not entitled to the relief that he is seeking. But the opportunity of filing a written statement is lost forever.
This is by Ramnath. Whether suits relating to copyright and damages are to be brought under this Act?
Yes, suits under copyright are also brought under this Act.
So we won't be taking any question as such because this is an open courts and people would, in fact, you would also, though you have given us sufficient time during a working day. It was a session which was not only engaging, but it also gave us the flip sides, what are the advantages and what are the disadvantages. But I just felt, as a curiosity, that whatever remedies are for a commercial court to the effect that it can be materialized, even the All India Judges Association case says that you can appoint more judges, and that to approximately 10% every year where the judicial officers are there. So these are all procedures which are recommended for the commercial. That fast track can also be adopted for the purposes of in the CPC also. What is your take on that?
No, that is why I said we must utilize this unless the bar is going to put pressure. This Act is not going to bring any difference at all. I've been saying this at least 5 to 6 times during the course of my presentation. I've said this. That is why, I mean, you can go into the website. We have formed an All India Bar Association called ICABA, ICABA. Please Google ICABA. All of you become members of ICABA. We will all jointly fight to see that the provisions of the Act become a reality. As a first step, as I said, we've already filed a PIL at the Supreme Court, which declares that all these changes must be brought to the 24 high courts in the country and the various states all over the country. So this must become a vibrant institution for us to exchange ideas, share details with regard to problems that we are facing in these courts, and hopefully we will get some relief through the Supreme Court.
So I was just feeling like you said that in the tender matters, there could be an appellate court. I just wanted to know, because at least in our high courts, the matter simpliciter goes to the division bench. So appellate LPA as such would not lie. So what is the procedure out in Madras out there?
No, Madras, we have a first court of first instance, which goes to a single judge, and then it goes to a division bench. So at several high courts, it goes straight away to a division bench.
Yes, our tender matters, resumption of land, resumption of plots. There are large number of cases which straight away go to the division bench, which they say that. So I was just thinking loud as to how the LPA would lie against that case.
It will not.
Yeah.
So as of now, unless you're going to file it in the form of a suit, if you file it in the form of a suit, then you have the benefit of a single judge, and from there to an appellate bench. But you're going to file it as a writ petition, it is not going to come to a single judge, it's going to go straight away to the division.
No, tender matters where you are debarred, you're blacklisted, these all matters, or you're not being shortlisted for the purposes of this thing.
But that also you can file a suit.
No, in our case, we all go to the division bench, and that's why I was just thinking as to how the LP would lie.
I mean,
So
if you want the facility of 2 hearings in the same court, you can, even in respect of a tender where you have been blacklisted, you can file a suit for injunction, and you take out an interim application that is dismissed. You can go still by way to the commercial appellate bench. Still can do it under the new act. It will give you a facility to go to 2 different courts within the intra-court system itself. But if you file it as a writ petition, then it goes to the bench. The only advantage is that if you file it as a writ petition, your possibly court fees are much lesser.
Yes, writ petition is definitely. Out here is 50 rupees per petition, per petitioner. I do not know about Madras.
It's 1,000 rupees in Madras, so it's a
per petitioner.
Yes.
Let's assume there are 10 petitioners, then 1,000 rupees per head.
10,000. 10 petitioners.
So we are quite lucky. We are out 50 rupees per petitioner.
Yours appears to be much lower.
Yes, yes. So thank you to all the participants who joined us on the live on the Facebook as well as on this platform for having the session, giving the real perspectives. What are the subtle differences between theory, practice, and the procedure? It was summarized in a nice manner, which just seeped into the minds and will be cherished for all times to come. And tomorrow, in the pursuit of our webinars, as we had last time stated that we had a series of 2 webinars on the bails. Tomorrow, Justice Ram Kumar, a former judge of Kerala High Court, would be taking the part 2 of the master series on bails. That is anticipatory and default, because regular bail and cancellation of bail is done already on the previous session. In the previous session, that is on 26th. Those who have missed any of the webinars can log in, subscribe, and share the Beyond Law CLC YouTube channel. And thank you to everyone, and especially to Mr. Rajah, who, despite the fact that he was quite busy, accepted our invite and shared his knowledge. Thank you, everyone. Stay safe, stay blessed. Namaskar.
Thank you.